She's gone and got one of the children christened behind his back, and she's moved both children to a different school and hasn't informed him of the move.
Clearly, Mum doesn't have any respect for Dad or his decisions.
At what point, when a father cuts a child off, can you look to remove PR? What rights do us mums have in this situation, please?
Wow, that's a very inflammatory question. Why do we want to do that? It's not about the mum's rights, it's about the child's rights. Hi everyone, and welcome back to the Legal Queen live show. I am your host Tracy Maloney, aka the Legal Queen on social media. I am a practicing family law solicitor and have been now for a number of years. During that time, I've helped so many people with their divorce, finance and children's issues, particularly when their relationship breaks down. So if you have a problem or an issue, or maybe just a question around family law that you think I could help you with, by all means, join me on the Legal Queen Discord. Come into the lounge, pop your hand up, and I'll get to you as soon as I can. Now, on with the show.
My question's regarding, it's my partner. He's got a court order. He's got stays with, mum's got live with. She's gone and got one of the children christened behind his back.
Right.
And she's moved both children to a different school and hasn't informed him of the move.
Yes.
He has tried to put it on hold or try to argue it, and it was put on hold briefly, but then mum's used the live with part of the order to sort of override that and managed to convince the council to approve the move without his approval. So
Right.
he wants to go back to court to try and get a joint live with order.
Yes.
Would that be possible? Is that sounding like it is a reason to do it?
I would be suggesting that rather than go back and get a joint live with order, because we haven't really solved the problem then, have we? You know, at the end of the day, he has parental responsibility. So actually, he can or he should be involved in those decisions. So getting a joint lives with order, in my view anyway, isn't going to affect that decision making that mum's doing. Mum's just going to go ahead and continue to make those decisions. The issue here is twofold: education and religion. If Dad strongly objects to the religion that Mum has, put the children into, then he can make an application to unravel that. And then the argument between him and Mum is, what religion should the children be involved with? And the second issue here is education. So if he disagrees with the school that the children are now in and he wants them to go to another school, then that's his application. Mum didn't consult me, and she should have done, but that's done. Like, we have to move on from that now. But actually, I don't want them going to this school. I think their best interest is to go to this school. So while he's there, if he wants to ask for joint residence, fine. But I don't think that should be his application, actually. I think that if he has objections to the religion or the school that they're in, then that needs to be his application. Because that's getting to the root of the problem, isn't it?
Yeah, it's multiple things, and it's to do with like medical as well. Like, they've had surgeries and he's not been informed. Like, every single thing that's a decision regarding the children, that's big decisions, is completely blindsided by. And when he's tried to gather the information by the authorities involved, they've just dismissed him and said that he needed to speak to mum because they'd only give the information to one parent.
But that's wrong. Oh, yeah, I say giving it to one parent, that might be their policy, but he has parental responsibility. You know, regardless of where the children live and what the court order says, he has parental responsibility. So, you know, the doctors, the school, anything like that, they should also be sharing that information with Dad. I understand a policy decision, well, we're only going to give the information to one of you because they don't have time to duplicate it. But again, getting a joint lives with order isn't going to solve that issue, is it? They're still only going to give the information to one parent. So I think that he needs to sit down, but he needs to sit down, and the application isn't going to fix mum's behaviour. Mum's still going to do what she wants, but the application needs to be, do I disagree with the decisions that mum is making in regards to religion and school? And if the answer to that question is yes, then he makes his application.
Right, fab. Thank you very much.
Brilliant. No problem at all. Thank you. again, I know that question was around the bigger ticket items, but it comes down to co-parenting, doesn't it? Clearly, mum doesn't have any respect for dad or his decisions, or his decision, involving him with regard to the children, and that's co-parenting. I think there's a lot to be said for parents that are able to co-parent. And look, we're all going to parent differently, aren't we? Once we separate, we're all going to parent differently. It doesn't mean that it's wrong.
It's just a quick one, really. So I've got a final hearing coming up next month in relation to a child arrangements order. And it's going to be sort of like where I finally get to move out of the contact centre, start having proper time with my son, overnight stays. It's sort of going to be like a progressive order. My question is, I suppose, looking for sort of like next year, in my final hearing, I'm wondering if I would be able to ask the judge whether he could give me permission for a passport and to sort of take little man on holidays and stuff in the final hearing, or would that be a separate sort of thing?
What I would suggest that you do, Matthew, is if you haven't got that application before the judge at the moment, before you get to a final hearing, do a C2. So a C2,
A C2.
Yeah, that's where you're making an application within existing proceedings. Because remember, the court's only got the power to decide on applications that are in front of it. So if you were to just rock up at the final hearing and go, oh, while we're here, can I get an order for, holidays and passports, all the rest of it? Judge might say, oh, well, hang on a minute. This isn't why we first came to court. So you want to do a C2 application and and it won't cost you to submit that into court because you're already in proceedings. And you're just going to be saying to the court, look, as part of the order, I am looking for, 2 weeks a year or whatever it is. And, 2 months before then or a month before then, could I also get the child's passport? And then as soon as I get back, I'll hand it back. So then you're in no doubt that the judge then has permission to actually make that application. Order.
Yeah, because it's just been a complete nightmare, like from start to finish, with sort of like mum always cancelling. Like I've lost a lot of money to the contact centres and things like that. So as well, I guess my last question is, when I get this order, how many sort of like cancellations, or how messed about do I have to be with arrangements and stuff, sort of like before I say, enough is enough, she's not sticking to the order, and I can actually take her? Because I know sort of like before it's even got there that it's going to be an issue. It has been for the last sort of 3 years. So nothing seems to be.
Yeah. What I would be suggesting, Matthew, is that there isn't a set number of times where we say, right, the other parent has breached the order 50 times or 20 times or whatever. If it's happening 2 or 3 times consistently and it's having a negative impact on the child, then I would be suggesting that at the final hearing, you ask the court for what we call a penal notice. And you say to judge, look, historically, this has always happened. I've been let down, or the child hasn't been made available, or whatever it is that relates to you. And in order to try to avoid this happening in the future, could we please have a penal notice placed on the order? What that means is that if mum were to breach the order moving forward, there's consequences, whether that be a financial consequence. I mean, in the most severest of circumstances, parents have been sent to prison because they continue to breach orders. And I'm not suggesting for 1 second that's going to happen in your case, but I say that to demonstrate the severity of the penal notice. But it's well worth them being included on the order where we have an inconsistent parent on the other side.
Yeah, okay, wonderful. Thank you very much for that. I appreciate that.
No problem. Thanks, Matthew.
At what point, when a father cuts a child off, can you look to remove PR? No contact, his choice, for 6 months, and not paid anything for 2 years maintenance-wise. What rights do us mums have in this situation, please?
Wow, that's a very inflammatory question. First question back to this person is, why do you want to remove dad's parental responsibility? Why am I always getting asked, how do I remove the other parent's parental responsibility? Why do we want to do that? If the parent isn't having any contact with the child, then chances are they're not going to be bothered about getting involved in the child's education or health issues or religion or anything else. So leave it be. Let it go. It's really, really difficult to remove a child's parental responsibility for obvious reasons. If the parent that the child is living with suddenly loses capacity or even worse, dies, what do we do with the child? No one has parental responsibility then because you've taken it away from the other parent. And a lot of times mums will say, but I'm scared that he's going to get contact with the child. Well, then go to court and get a prohibited steps order that prevents him from having contact with the child if you think that the child's safety is compromised. But the answer isn't to apply to remove PR. The courts only do that in extreme circumstances.
I mean, I don't know if you can answer this on this platform, Tracy. What are those extreme circumstances so people know what you mean by extreme?
So the darkest of situations where we have sex offences against children is the most obvious one that comes to mind. You know, where we have trafficking, where we have, you know, severe extreme circumstances, you know, very, very dark, where all of that, you know, without being too explicit, all of that is where we have parental responsibility moved. Where we have parents that are addicts and just not involved in the child's life, or maybe are inconsistent, you know, no, we don't remove PR in that instance, and we don't take them off the birth certificate. I get asked that a lot as well. You know, father hasn't seen the child for 6 months or a year. I want him removed off the birth certificate. Why? He's still the child's father. He might be a deadbeat dad, but he's still the father. And therefore stays on the birth certificate. And just to go on, actually, Captain, the last part of that question was, what rights do us mums have? It's not about the mum's rights, it's about the child's rights, isn't it? When we're talking about children application orders?
Yeah, and isn't it in the Children Act that it is a child's right to have a relationship with both parents?
Yeah, absolutely. So it is the answer to that. Absolutely. It's the child's right to have a relationship with both parents. For those of you on the TikTok live, it's definitely not down to the other parent with conduct of the child to say, but what are my rights? If you feel that the child's safety or welfare is compromised, then by all means make an application to the court for some preventative measures. But it's not your right as an adult.
And do you find, Tracy, being a family lawyer, that I'm going to be quite careful what I say here, but parents will make an application to court because I'm saying dad here, dad was 10 minutes late dropping the kid off after contact?
Yeah, I mean, effectively what you're asking me is, do applications get made to the family court where it's a co-parenting issue rather than a legal issue? And sadly, all the time, you know, and that's why if you make an application to family court right now, and I'm talking about England and Wales, for those of you that might be joining me from elsewhere, you're waiting 3 to 4 months before you get a hearing date. And it's because of the volume of applications that are being made, particularly in the city courts, so London, Birmingham, Bristol, etc., particularly in those city courts. And when you sort of identify the reasons that the applications are being made, typically it's because of co-parenting. You know, it's not legal issues. It's because one parent doesn't agree with, you know, the bedtime routine that the other person has. I had a caller on earlier and she said, well, CAFCAS have recommended overnight stays, but dad works shifts. Well, that's not a reason to not allow overnight stays to happen. Now, she did go on to mention something else as well, but it's not a reason just because dad works shifts. Lots of people work shifts. Does that mean everyone that works shifts can't have overnight contact? Absolutely not. We have to be flexible as a family. You know, we have to learn to co-parent, as hard as that is for people.
Yeah, and I fully get that. It's hard, isn't it, when two parents split up?
It is hard because they're trying to make decisions in the best interest of the child when they're not in a great place emotionally. I get that. You know, if your relationship is breaking down, it's tough. Emotionally, it's tough. And then you're being asked to be reasonable and logical when it comes to the children having contact. And for many, it can be near on impossible. But therein lies the difficulty in being a parent. You know, you have to find a way through it. You just have to, for the sake of the children.
So basically, I wanted to ask about child arrangement order. So the current child arrangement was done 2 years ago, and the father of the child lived not too far from us. And my daughter was at that time only 2. Then she started nursery, and he still lived very close to us. But then now she is 4.5, and she's about to start primary school. And he moved like a year ago. He moved away, and I don't know where. I know that he still lives in the same city, but I don't know where exactly, and I don't know if it's going to be too far from the school of my child, because obviously I don't want her to travel like 2 hours every day just to school and back. So am I allowed? My question is, am I allowed to find out where he lives? That's the first thing. And another thing, if I am not, um, can I change the child arrangement if he's late for school?
So I'm a little bit confused, and I'm not sure that you're
Hmm.
asking the right questions, but bear with me, Jazz. We'll work
Hmm.
through it. So are you
Yeah.
allowed to find out where he lives? Well, yes, because he's your daughter's father. So you would use your best endeavours to find out where he lived, because you're going to need his consent on a few things. But my question back to you is, why would you need to? Because is he
Um,
seeing your daughter regularly? I take it.
yes, he does. He has
Oh, I
3 days with
see.
her and 3 nights,
And
and I have
so,
4 days and 4.
so Jazz, let me jump in again. I didn't appreciate that. I beg your pardon. I
Mhm.
thought that he wasn't seeing her. Why do you need to know where he lives then, if he's having regular contact with her?
Because because of the school. So I don't want my daughter to travel
I
far away.
see.
So
So you
like I
wouldn't.
would like to her to. Sorry,
But
go
but
on.
wouldn't you simply say to him, "This is the school I want her to go to. Have you got any objection?" You don't really need to know his
Oh,
address. Now,
you know,
if he says to you, "No, I don't want her going to that school. I want her going to this school," which then requires you to travel 2 hours, that's when you make a court application. So
mhm,
that's why I come back to, I'm not so sure that you need his address. I think you're
mhm.
just saying to him, I'm thinking this school. Would you agree? If he says no, fine. We have a dispute. We would initially try to sort that out with mediation. If not mediation, then we'd be making a court application.
Yes, so he didn't make an objection when it comes to the school, but at the moment he takes her to the nursery, and he's always like 3 hours late every day. And I don't want this to happen for the primary school, because obviously primary school is more serious now, right? Because we don't pay for primary school, but for the nursery I had to pay, so that was not an issue. But now I don't want her to be late every single day if he travels far away, if that makes sense, because she has to be there at 9 o'clock in the morning.
Right. So again, I'm not seeing what the issue is. What's the issue
So
here?
so he doesn't want to tell me where he lives, but I wanted my daughter to be actually, the school to be in the middle, like halfway for me and halfway for him.
Okay, so if you find out his address and you find the school that's exactly halfway between you and him, do you think that is going to improve his punctuality? Absolutely not.
I believe yeah, I
Well,
don't know, maybe.
I don't think it will. If he's running 2 or 3 hours late for a nursery run, there's every chance he's still going to be late. I don't think that
Yeah.
you can base the
Hmm.
decision as to where to put your daughter into school around the fact
Hmm.
that, dad runs late and you're just trying to outweigh that issue. I think
Can
choose
I
the
ask
school
one more
that's
question?
best. Yeah, sure.
So if he repeatedly is late for school, let's say from September, is it enough reason for me to apply for court to change the days for him?
Have you got a court order in place at the moment?
Yes, I do.
Well then, yes, you can, absolutely. If it's not
And
working,
how?
you just go back and do a C-79 application. But if it's not working
C-79.
and your child is just being left at school, I don't think you'd need to change the court order. You just exercise your parental responsibility, and you'd have to start making arrangements for after school club, or you'd have to collect her. Again, this is co-parenting, isn't it? This isn't like a legal issue. It's all co-parenting.
Yeah, I'm more worried about like dropping her off to school because I don't want him to be late. Because with the collection, it's not an issue, but the morning thing is just an issue I've noticed.
Yeah. So as I say, this is down to him not being very punctual, not being very, not putting his priorities in order with regards to getting her to school on time, which is why my view, if I was in your shoes, I'd be having a school closer to where you live because you are the more consistent. But that's entirely up to you.
Yeah. Okay. Thank you so much.
No problem.
So
Okay.
it's C-79 form in case that
C-79.
was
Yes. Yeah.
C-79.
Yeah.
And I can
Okay.
apply by myself without any solicitor, right?
Yeah, you can.
Okay.
All right.
Perfect.
Thanks.
Thank you so much.
Bye-bye.
My son's father has a contact order, but hasn't seen him since October. He has now said he doesn't want to have PR and wants to give up everything. He said he will only do it if my partner adopts him, but adopting costs a lot, and I don't want to drag my son through a lot of hassle. Is there a different way for my partner to have PR for my son? I'm due to be married in 2027. Would it be better to wait?
Well, yes, wait so that the person is a step parent. And then how you get parental responsibility in that instance is that you, being the biological mum, and the biological dad would sign a parental responsibility agreement. And that then gives the step parent parental responsibility as well. Okay. Now, if she doesn't want to wait until they're married, the courts will generally give PR to a partner if they've been living with the child for 3 years or more. Okay, so it might be that they've been living together for a little while, and it's really important that he have parental responsibility for the child. So that's another way to do it. But again, you don't have to go to court and have a hearing as long as the biological parents or everybody with PR already is in agreement to signing the parental responsibility agreement. That works. If they adopt, and I know she said she didn't want to do that, but if they were to adopt, they being biological mum and the stepfather, then biological father would lose his PR.
And that's adoption orders are really, really difficult and time-consuming applications, aren't they?
They are, because if biological dad is just not involved, then the court could say, but why? Why are we adopting then? Biological dad isn't causing us any concern. He's not interfering. He's not involved, sadly. He doesn't want anything to do with the child. Why are we removing his PR? Why are we even thinking about adoption? In that case, they would just be looking for the step parent to have PR. And it's really important because let's say that mum is away for the weekend with, girlfriends or whatever, and stepdad is in charge, and then something happens to the child and he has to take her to hospital. You need PR in that instance if you're living with a child. So the courts are more in favour of that than removing biological dad's PR by way of adoption.
And so if it went to court because biological dad didn't agree to PR, the chances are, would the court allow stepdad to have PR without too much trouble?
Yeah, absolutely. There would be no trouble. If biological dad wasn't going to give his consent, I mean, step parents are automatically given. No, sorry, I shouldn't. They're not automatically given, but the court will, just as a matter of course, give them PR because they're living with the child. Absolutely, yeah. Now that parental responsibility is court ordered. So then, if the step parent ends up divorcing, then there's every chance they're going to lose their PR because the PR in that instance is court ordered.
Just talking about orders, actually, we've got an order with our children that's been in place since they were sort of 8 years old. They're now 14. At what
Yes.
stage would you expect the children to start leading more about where they want to be rather than sticking rigidly to the order? I mean, Mum and I co-parent really well,
Good.
ex-wife, but it's at what stage should we start loosening and just letting them choose?
Yeah, I would say any time from now. Typically, when a child hits teenage years, let's imagine that you haven't separated as parents. Once they get to that 13, 14, 15, we are starting to allow more independence. So we're allowing them to maybe get on public transport and go and visit a friend, or, have overnight stays, maybe for the weekend, or whatever it might be with friends. So I would say now is a great time to be guided by them. And it's a sign of really good co-parenting where, let's say it's your weekend, Steve, and your ex phones you or texts you to say, actually, they don't want to have contact with you this weekend because one of them's been invited to the local, village fete, and another one's been invited for a sleepover at their best friend's, and for you to say, no problem at all, that's fine. What you could then say to mum, and this is real good co-parenting, is, well, maybe I could get a night next weekend when they're less busy. And you would hope that the other parent wouldn't then respond with, well, hang on a minute, that's my weekend. So it's about having that flexibility between the parents and recognising that 14, 15 is the exact time when the kids are going to not want to spend weekends with mum and dad, let's be honest, because even if you guys hadn't separated, they probably wouldn't want to spend the weekend with you. And then, of course, organically, that order's going to fall away at 16 anyway. And what I mean by that is that, if the child doesn't want to come and see you and you then think, hang on a minute, this isn't down to the child, this is down to my ex, I'm going to enforce this order that I've got. If the child's 16, the court will say, look, off you go. I'm not dealing with this anymore. The child's 16 now. They'll vote with their feet.
That's really helpful. So normally at 16 is when the order, children's arrangements order sort of fall by the wayside.
Yeah. So some orders, Steve, will be a bit more specific, and they will say 18, where we have children with special needs. I've seen orders that go on a lot longer than that, into their 20s. But that's where we have maybe a child with special needs. But typically at 16, you wouldn't be taking the matter back to family court, because the judge, again, always thinking about the best interests of the child. And at 16, they're that bit closer to being an adult. And it's like, look, if they don't want to spend the weekend with you, respect that, start to then respect what the child wants a little bit more.
That's really helpful. Now, things are in a good place with myself and my ex-wife, and we actually have a calendar that the kids also have access to as well, so they can see where they are at different places and different times. And also holidays, we try and plan sort of 3-6 months in advance, so we can go and book holidays and things like that and have that flexibility. But it's good to know.
It's so good, Steve, and I really want to thank you again for sharing a positive story. A lot of what I get on my social media is very negative, people who are in the court system or they're struggling to co-parent. So it's lovely to hear a positive story. But what I would like to add to that is, doesn't that reflect on your children as well? In other words, how you and your wife have handled this is teaching your children, indirectly and directly, there's going to be moments in their adult life where they come across a work colleague, a boss, a neighbour, whoever, that they just don't get on with. And you and your wife, I'm sure, are a great example of, okay, but we still have to rub along with them. There's going to be people that we meet in society who we have to just rub along with, and we just don't like them. And I think that says a lot. It teaches our children a lot about having tolerance, having patience, having respect and manners. It's so important. And a lot of times I think the problems in our society stem back to really good parenting, or co-parenting is what I would say to that.
Yeah, no, thank you. I completely agree. I mean, I would say it doesn't happen overnight. It's taken 8 years of patience and perseverance on both sides.
Yeah.
And we still have disagreements, but I think by having that good conversation, that good relationship now, we can work through most of that. So I'll leave it there. Thank you so much, Tracy.
Brilliant. Thank you, Steve. Thanks so much.
When it comes to like Christmas and Easter and any other, say, religious holidays or just holidays in general, how do the courts sort of split that between mum and dad?
So they will be guided by what suits the family, and what the child has been used to. So I've done lots of different Christmas orders. If the children are very little, and they're still having nap times, maybe in the middle of the day, or they're going to bed early, or they're not really aware that it's Christmas Day, the courts might say, well, look, Christmas Day with one parent and then Boxing Day with the other parent. As the children get older, we will chop and change. Some parents, if they live very far apart from each other, will have the even years, Christmas days with them, and the odd years, Christmas days with the other parent. If they geographically live close to each other, and again, depending upon the age, some orders I've done is they'll wake up at mum's Christmas Day on the odd years, and they'll wake up at dad's Christmas morning on the even years. And again, because both parents want to be there Christmas morning to open the presents with the little ones. So it will all depend on the family. I've done children's orders where mum and dad have completely different religions, and maybe one of the parents isn't fazed by Christmas Day because actually they don't celebrate that, but they're really particular about another religious festival. So, whatever suits the family. If we can't agree, then obviously the judge is then going to apply an element of fairness and do alternate years, is typically what happens.
I got with my ex back in 2012. I was left my grandfather's house in 2015, and we broke up last year. We had our daughter in 2016. We broke up last year, and going through his solicitor, he is trying to claim part of my grandfather's house. He did help to do up the house. Does he have a leg to stand on?
The key piece of information that isn't here is whether they're married or not. I'm going to assume they're not. I don't know why I feel that, but I just don't feel that they're married. In which case, it would be for him to prove that he's made a significant financial contribution that has directly led to an increase in the value of that property, and thereby he should now have a claim to it. But if they are married, then he will automatically be entitled to a share of all the assets. So whether they're married or not is really key in what I'm about to say.
She is typing back to me as we speak.
As we speak. We have the bubbles.
Not married.
Not married, well then it's up to him to show that he has a legal and beneficial interest, and he will do that by convincing either her or the court, if they can't agree, that his significant contribution, financial one, directly led to the property increasing in value. I was just going to say, in most cases, my suggestion to people is just give them the money back. If someone's paid 5, 10, 15, 20 grand into a property that's in your name, the relationship breaks down, give it back to them. That's the right thing to do. That's the morally right thing to do, strike a deal, give it back to them, because they're going to walk away having invested 10 grand into your property. You get to keep the house. Not really fair, is it?
No. When she says here that it did help do up Dad's this house.
Yeah.
I mean, this is me just presuming here. If they're saying that and they mean it all just gave a lick of paint.
Yeah. Oh, that's different. That's why we say a significant financial contribution. Has it been significant? I'm talking thousands of pounds. Has it been something that you've invested in that has now caused the value of the property to increase? So the examples I always give are replacing windows, putting a new driveway in, paying for an extension on the back, a new central heating system. It's not just decorating the front room or, upgrading the bathroom.
It says he was paying me £200 a month to help with bills.
Yeah.
Does that count as financial contributions?
No.
Most of the renovations, less than 10k total between us.
No. So the £200 doesn't, because if he wasn't living with her, he'd be living somewhere else and having to pay, I'm guessing, more than £200 a month. But I think what she wants to do here is just come to an agreement, offer him 5k or whatever. I don't know. I'm pulling figures out the air. But just, if he's invested in it, and I think she accepts that he has, offer to give him his money back, because he's got no benefit from that property. That's what I think morally, that's the right thing to do. Healing Your Soul asks, is there a risk and he was only given 8 hours? Can he take the child abroad on holiday? Look, there's always a risk, isn't there? A parent can abduct a child. It happens all the time. So I think absolutely there's a risk. But where you have that child arrangements order in place, then at least you can take it back to court and have the court enforce that. It's better to have an order in place from the UK courts than not. Because if a child is taken without an order in place, we are at the mercy of the country in which the child is now in, if that makes sense, okay? So yes, there is always that risk, but at least you've built in some protection with the mere fact that you've got a child arrangements order, okay? Not married, we have a 4-year-old together. House is in his sole name. Am I entitled to a portion of it? Suzanne asks that question. You're not, Suzanne. Not if the house is in his sole name and you're not married. But if the relationship is breaking down and you have to move out, you can make what's called a Schedule 1 application because you have a 4-year-old together. And what that means is that you are making a financial application on behalf of the 4-year-old, not on behalf of you, because you're not his wife, but on behalf of the 4-year-old, and you're asking for some financial help in order to house or provide for that 4-year-old. Okay, that's called a Schedule 1 application. Can I change my daughter's surname? She's got the same name as her dad. Bryony Campbell asks on TikTok. Well, yes, you can, Bryony. If dad has parental responsibility, you are going to need his consent to change the name. If dad doesn't give his consent, then you're going to have to go to court and get a court order that gives you permission to change the child's name. They're not easy applications to win because the court want to know, why is it in the best interest of the child to have her name changed just because you and dad are no longer together or whatever the situation might be. So you do have to make sure that you put a strong case forward there. And then, of course, I get bombarded with people that say, well, I just went ahead and did it anyway. And yes, a lot of people do without a court order and without dad's permission. But if dad finds out and wishes it to be turned back, chances are the court will turn the name back, okay? Do I offer just financial orders if I do the divorce myself? We offer all sorts when it comes to family law. We have a lot of clients that literally are what we call ad hoc clients. They'll come back to us as and when they need to. But yes, we can just do financial orders if you want to do the divorce yourself. We don't even have to do all of the financial order. Sometimes we're just drafting the order and sending it out to the parties. Sometimes we're just doing a court application for them and then we don't hear from them again. Absolutely fine. Whatever help you need from us, we can present you with a package that will assist. You don't have to have the gold ribbon service where, you know, I'm holding your hand every step of the way. That's not for everybody. I get that. Sometimes you don't need it, but sometimes you can't afford it, and that's fine too. But we will try to, usually via email. If you email me, I'm going to be able to answer and suggest what's best for you. We also have a variety of expertise in the firm. So it's not just me who is the most senior at the firm. You know, we have right down to my assistant, who is a trainee solicitor, although she's about to qualify in about 2 to 3 months, Jess. And she's great at helping with the forms and obviously at a far cheaper price than I am. So I always say, just drop me an email, reach out, let me see how you need help and we'll see how we can help you, okay?